This case, the prosecution wants to argue it's a very simple case. Donald Trump was trying to cause Michael Cohen to hide a payment to an adult film star to affect the election, to interfere with the election and do so corruptly, to hide things from the voters. At the same time, their summation, and I saw the beginning and the end of it, was 5 hours long. It was very complicated and it was mostly easy to follow, but there were times when it got kind of weedy. How difficult is a case like this for a jury? And is it made easier or harder having two lawyers on the jury?
Well, it's interesting. We've talked about this. Lawyers on the jury does change the tenor because it's human nature for people to kind of go, well, what do you guys think? But if they're responsible and follow the rules, they're supposed to, of course, only find facts and deal with the evidence, not give some sort of like random legal advice to the jury. You know what I mean?
But does the jury look to them and say, you understand how to read the law, you're more schooled in this than I am, can you take a leadership role here to try to help us understand what's going on?
Yeah, I think that could happen. I mean, what's so fascinating now, 3.5 hours into the deliberations, that we get this note is we find out something. We don't know what we're about to find out.
We don't know if it's a note. We know it's a ringing of the bell.
A ringing of the bell,
so
right.
It could be a note, it could be a question, it could be
a question
verdict.
or more. We're waiting on that. But here we are 3.5 hours in. They've had time to both digest what you just described, Katie, those lengthy arguments yesterday, as well as the jury instructions this morning. And so we were all following and reading those instructions and trying to figure out, okay, where did it all land? They looked fairly straightforward to me. And the instructions are, of course, designed to give everyone guidance on how to have these conversations that they've now been having for about 3.5 hours.
So Mershon has taken the bench. We have a little bit of color on what the ring sounds like, a very old-fashioned telephone. Donald Trump is standing there. He's holding papers. We're going to find out more in just a moment. It is a note from the jury, according to Judge Mershon. So, okay, they have a note from the jury, and they are going to potentially, if it's a question, have Judge Mershon reread back the jury instructions.
Just to be clear, that if it's a note for amplification on the law or a note for witness testimony, either way, it's going to take some time. Because if it is a question of law, he does need to hear from the parties about what they think should be said. And if it's the thing that takes even more time is if it's a read back, figuring out exactly what needs to be read back is something where the parties need to figure out exactly what that is. So that usually takes time to answer that question.
So the note was sent at 2:56 p.m. just before we came on the air and wondered what the jury must be thinking. There are 4 requests from the jury. Catherine. 4 requests. What does that lead you to believe?
It could be a request for readback, request to, tell us again what you meant by intentionally. It could be an assortment of things. 4 requests, that's separate.
Okay, hold on. Before you have to guess, I can fill us in. It reads, we, the jury, request David Pecker's testimony regarding the phone conversation with Donald Trump while Pecker was in the investor meeting. They also want Pecker and Cohen's testimony about the Trump Tower meeting and Pecker's testimony about his not finalizing the transfer of McDougal's life rights to Donald Trump.
Yeah, this is interesting, and let's get into it. We now have the first clues about what they're discussing, and we want to be as careful as possible. The fact that they're asking about something may or may not be what it looks like at first impression. For example, Katie, a meeting that the prosecution brought up because they say it's bad for Trump. The fact that the jury's discussing it doesn't mean they agree with the prosecution that it's bad for Trump. But these are definitely key questions about reviewing evidence, testimonial or otherwise, regarding the tabloid plot. So we have Mr. Pecker, who, of course, was the first star witness. He, of course, ran the Inquirer. I think people remember. He was the AMI chief. The Trump Tower meeting is important to the prosecution's case, and our prosecutors can speak to this as well, because that's where they argue the catch and kill plot was developed. So the DA's team has argued that Trump Tower meeting was key. And then Michael Cohen's testimony about that meeting is, again, 2 different ways to look at what was alleged to be the beginning of that plot.
So one thing I just wanted to say, I mean, I totally agree with what Ari's saying, which is that I caution people to not tea leaf read too much. I have seen notes which you think are really good for one side or the other, and it's the opposite. But the one thing I do think is good for potentially for the state here is asking to have Michael Cohen's testimony read back. David Pecker is not surprising because there was not a lot of attack by the defense on David Pecker, so you can understand why that, as the first witness, is something they need to have their memories refreshed about exactly what he said. But the fact that they are asking for Michael Cohen after the onslaught he took is interesting, because that means that there isn't sort of unanimity on, like, we are not going to focus on what he said. We do not believe him. It is not useful. It is, to me, that has to be viewed as at least a potentially good sign that they are like, yes, he may need corroboration, but we want to hear what he has to say.
Well, they're also asking for Pecker, so doesn't that indicate that they want to see how those two stories align?
Oh, exactly. Absolutely. Yeah. And it really makes sense. I mean, nobody is thinking, there's no way that a jury is going to say, oh, just because Michael Cohen said it, we're going to take it to the bank, and without any corroboration. So this makes total sense. And David Pecker, I really do think, because he was not really attacked by the defense, it makes sense that they'd be, you know what, that's the first witness. Let's hear what he had to say again.
So they have the laptop, they have all the evidence, but they don't have testimony.
They don't.
Why don't they have testimony?
That has to be read back. So that's the court reporter coming into the courtroom and literally reading it back. And as Ari said, it's important that for the prosecution, they're going back to that Trump Tower meeting where the alleged conspiracy was hatched, where the catch and kill was hatched. That means they've just started right out. We're going to focus on that. And also, what did Michael Cohen say about that meeting? Because they've asked for his testimony.
It's interesting they're starting at the beginning as well. They're not going to the end of it. They're saying, when was this initial meeting had? What was said at this initial meeting?
Yeah, and I would put it like this, and again, this is what's interesting. We're all processing it live. Mm-hmm. I'm not going to say this is great for the prosecution yet, but I will definitely say it's not bad.
Yes.
By which I mean they're looking at the theory of the case. You know what would be bad? If they were asking about comparing Michael Cohen's description of this now much discussed call to the bodyguard to something else. If they were asking about places where the Trump folks attacked. These are questions that at least show the jury has begun, and this has come out of their first 3.5 hours of discussion and deliberation. They have begun by saying, what happened at Trump Tower? What was the tabloid plot? And was it part of an election crime, potentially?
Can I just tell the viewers sort of what's going to happen now, because there will be delay. And what happens is the prosecution and the defense now are taking this note and figuring out, respectively, what pages and by page and line responds to this. So they are going through everything David Pecker said to figure out what it is. Then they confer with each other. There will always be a disagreement about exactly what it is. And then those disagreements are brought up to the judge, who decides what exactly is responsive, and then there is the readback. So there'll be some time delay now.
And can I ask a question before?
Yeah, go ahead.
Because I'm in and out of here with you, and we're going to be doing this for a while.
Yeah.
But a question for Catherine is, specifically in these kind of courtrooms that you've been in here in New York Court, how long would you expect this readback to be, based on what Andrew
And I was just going to say, the judge said we're going to end today at 4:30. I'm wondering if he'll tell the jury, you know what, if we do this today, it might take us past 4:30, so therefore we'll do it tomorrow. But that's, because he's promised them 4:30, they may have plans, but if he lets them know...
He said 4:30, we can reassess and see where you are.
Exactly. So they have to, as Andrew said, there's usually not an agreement between both sides. No, they don't want that part of the testimony. They want this.
I think it's interesting that, when we're talking about the Trump Tower meeting and the deal with David Pecker and Michael Cohen and Donald Trump, the defense team tried to paint this as standard operating procedure for any candidate or campaign in dealing with a journalist, and saying that what AMI was doing, catching and killing stories, was what all of us as journalists do when we are dealing with a campaign. It's normal for a candidate to spin. A campaign is a conspiracy between a candidate and another person to get them elected. They tried to trot out Rahm Emanuel and others to say that this was absolutely fine. Do you think that that question is potentially going to come up with these jurors? I mean, we know that is not standard operating procedure. We know that is way beyond the bounds of journalism. It's not what a traditional or a news outlet or journalist does. But the jurors might not know that.
So the defense is going to very much look at the precise wording of the note, and they will be arguing for as much of the defense case coming in as responsive, and the judge has to make that decision. In this case, you can imagine the state will say, no, that is not about what happened at the meeting. That is about how they should be thinking about the meeting. And so there will be that. That is exactly why there will be some delay here. One thing that, to Catherine's point about sort of how the judge could proceed, is because this either four sort of requests, the judge could say, if I want to get you out of here at a certain hour, we'll do it sort of seriatim. I'll take the first one and we'll get you a response to that. And so that it sort of doesn't all happen at once.
Yeah, I would add to that. You've got, as we were discussing and Katie pointed out, the comparison here. So the jury's interested in getting more information about this infamous Trump Tower meeting, and they're asking for David Pecker's description of it and Michael Cohen's. And one can reasonably infer they may then compare that. Their jury instructions actually urge them to do that, to look at testimony, not notes, to use their common sense and their recollection.
To be a fly on the wall behind these closed doors in the courthouse that has seen no shortage of famous, influential, or wealthy criminal defendants. 12 New Yorkers, 7 men, 5 women are right now debating the fate of a former president of these United States, and they have questions. The jury in the historic Trump criminal election interference hush money trial is, at this moment, deliberating on the 34 felony counts Trump is charged with by the Manhattan District Attorney. Just in the last few minutes, a second note has been sent from the jury. They are asking to rehear Judge Juan Merchan's instructions to them. That's just over an hour from the first note they sent, in which they requested testimony from David Pecker and Michael Cohen. If there are more updates from the courtroom, we've got our laptops open. Our journalists who are inside the courthouse standing watch over this jury as they deliberate are updating us, and we will update you as soon as we know anything. As of 4 p.m., the jury had deliberated for more than 4 hours. That was after yesterday's marathon day of closing arguments, more than 7 hours between the closing argument delivered by the defense and the prosecution. This morning, Judge Juan Merchan delivered those sometimes complicated, kind of weedsy, but all important jury instructions, where Judge Merchan explained how the jurors are to apply the law to these facts in this case. Something that matters in any case, but in this one, where Donald Trump faces felony charges, not misdemeanors, because the allegedly falsified business records were to conceal another crime. The jury instructions took on a new importance. The judge told the jury that they did not have to agree amongst themselves what the underlying crime was. The New York Times reports this, quote, the jurors did not have to agree unanimously on the unlawful means they might determine that Trump used in the election conspiracy that prosecutors allege took place. Had the judge required them to be unanimous on the unlawful means, it might have become far harder to reach a verdict. The judge went through each and every single one of the felony counts, each one corresponding to an allegedly false record, 11 checks, 11 invoices, 12 vouchers. Judge Merchan explained what needed to be proven to show that Trump falsified these records or caused the records to be falsified. Now, as for the defendant, Donald Trump, he's now forced to wait, just like every other criminal defendant in the country. Any moment now, he could find out whether he'll be asking the American people to send him to the White House with a criminal conviction on his record. He has been spending his time posting a lot of nutty things on the platform Truth Social. Earlier, he said he does not know what he's been charged with, even though they were read to him while he was there. Just before that, he posted a rant from outside the courthouse where he claimed Mother Teresa could not beat these charges. As if Mother Teresa would ever be charged with concealing hush money payments to hide an affair with a porn star. We're sorry we said her name in that sentence. Wait and see mode in the Donald Trump election interference hush money criminal trial is where we begin today with some of our most favorite reporters and friends. With us at the table for the hour, MSNBC legal analyst Andrew Weissmann is back. Also back, New York Times investigative reporter Suzanne Craig. Also back, former U.S. Attorney and former Deputy Assistant Attorney General Harry Litman's here. And once again, outside the courthouse for us, my friend and colleague, NBC News correspondent Vaughn Hilliard. Vaughn, what's happening right now. I want to look down just to see what's happening inside the courtroom, but I won't do that. I'll let you tell us.
Well, first of all, I'm wondering how many rings of the bell we're going to get here, because it's not clear when the jury from the jury room rings the bell into the courtroom, whether they have a verdict or whether they have a note with questions. And now, so far, they've rung in twice with two different notes. The jury, just in the last 2 minutes, re-entered the courtroom, and there were two requests from the jury to Judge Merchan. Number one, there were four specific parts of testimony, including from Michael Cohen and David Pecker, that they want to have reread to them. Judge Merchan informing them that it will be about 30 pages of testimony that would require to be read back to them. That could last up to 30 minutes. They are still in the courtroom trying to go and gather those pages of transcripts from all the way back in April to May 13th when Michael Cohen testified. The second request, here's the big one, is to reread the jury instructions that Judge Merchan delivered this morning. Now, to note, this is the packet of jury instructions. Judge Merchan read it once, and it took him an hour and 26 minutes to do so. We've been saying it's complicated, the case is complex, the jury instructions are complex because it pertains to a lot of legal statutes under New York state law. And so now the question that Judge Merchan just put to the jurors is, do you want the whole thing read back to you or just a specific part of the jury instructions? That is what we are waiting to hear from this jury here in this closing hours of day one of deliberation.
So, Vaughn, let me just read back to you the first part of this, which was the first ring of the bell. Is it an actual bell?
We're told by Lisa Rubin that it sounds like a 1960s telephone. So if that takes you back, sometimes government's a little slow to update, but there you go.
Okay, that was my burning question. Now you know more about me probably than you needed to. So these were the four questions at the first ring of the bell were the jury expressed they wanted to see. These are the transcripts they're running down. One, David Pecker's testimony regarding the phone conversation with Donald Trump while Pecker was in the investor meeting. This came up closer to the end when I think the prosecution reminded, it came up maybe in someone's cross, or I don't remember why it came up, but this was Trump on the phone with Pecker. He pulled him out of a meeting, and I think what he said was, I don't pay for stuff like this. This seemed like an important part of tying Trump to the whole scheme, Vaughn.
Right. It's around the Karen McDougal purchasing of the story. He said he was at an investor meeting in New Jersey when he got this phone call. His assistant came in the middle of the meeting and said, Donald Trump is on the line. He stepped out, and he said that's when the phone call took place about the specifics of the Karen McDougal story. And David Pecker testified to this jury that he, in fact, thought the story was real, incredible, based off of the fact that Donald Trump told him that Karen was a, quote, nice girl, and that he urged Donald Trump on that phone call that the story should be purchased. And Donald Trump followed up by saying that he should talk to Michael Cohen, about actually executing that arrangement. Again, this all hits at the beginning of this conspiracy that the jury is having to deliberate over. And we have from the jury instructions that the jury is now asking to be reread to them that Michael Cohen was an accomplice in that. And under New York state law, being an accomplice, you have to have corroborating evidence or testimony. And so that's where it's interesting to see David Pecker, multiple conversations that Donald Trump had with David Pecker, being asked to be reread back to them, that specific testimony, because when you go and match it up, you see some corroborating testimony, not just documentary evidence or circumstantial evidence, but actual testimony that David Pecker links Donald Trump to the beginning of the conspiracy.
Yeah, Andrew Weissmann, I'm going to ask you to pick up on Vaughn's point. Let me just tell our viewers what's happened in the last 60 seconds. The jury has been dismissed for the day. That was after Judge Merchan brought them back in after they rang their bell a second time. He told them they were going to run down the transcripts of this testimony that Vaughn just described perfectly. We'll tell you what the other three pieces of the testimony are that they want. But the jury also wanted the jury instruction read back to them. Andrew, you waved around your packet. As Vaughn just said, the whole thing took about an hour and a half to read. So Judge Merchan asked them to clarify, and I don't know if we have their answer yet, whether they wanted the whole instruction or just part of it. So that's where they'll pick up tomorrow morning at 9:30.
Right. And so this gives the judge and the parties an opportunity to have their ducks in a row so that when the jury comes back, they can be ready to go. Just so that everybody understands, this is a pretty normal part, as Harry knows, of when you have a jury that's out, they can ask for two things. One, they can ask to have some kind of instruction reread or some question about the instructions. And for a rereading, it's pretty simple. Once the jury responds and saying that if they want the whole thing read back, he can deal with that, or some portion. He just reads that.
I saw in his instruction, he said, I won't give this to you, but I'll read it to you again. Why doesn't he give them a copy?
Quirk? That is a great question. A quirk of New York state law. I was a federal prosecutor. Like this would go back with many of the judges would send it back there. Some judges didn't because they really thought that it might have them sort of parse it too much. But that is something that in other courts, but not in New York. In New York, they can ask to have it read. But more typically, they ask questions like, can you please specify some more what beyond a reasonable doubt means? Because that's the level of certitude in your head, how to sort of deal with that, because language is imprecise. How do you sort of convey to somebody what a level of certitude is? So that's a really common question. The other questions, the more interesting one, which is the first note, where there's endless speculation that always goes on as to what does it mean, and you can argue it each way. When I was a prosecutor, I always argued it against me. I always, no matter what note came in, I was like, it's awful. No matter how good it was, no one ever wanted to do trials with me because I was like, we're losing, no matter what happened. So I'm a terrible person
I was
to
like
ask.
that on campaigns.
Yeah, that's so funny. That's what I said this to somebody on Pod Save America, and that's exactly what they said.
Yeah.
I was exactly the same way. It's
Every
very
good
pessimistic.
operative always is certain that they're going to lose.
Yeah.
Good evening from New York. I'm Chris Hayes. The criminal trial of Donald Trump was turned over to the jury today. 12 of Trump's fellow New Yorkers, I say that somewhat tongue-in-cheek, deliberated for a total of about 4.5 hours today before being dismissed for the day shortly after 4 o'clock. Now, this afternoon, the jury sent 2 notes to Judge Juan Merchan requesting to rehear 4 sections of witness testimony as well as the judge's instructions. Court will reconvene tomorrow morning at 9:30 with the court reporter reading back those relevant parts of the transcript before the jury continues to deliberate. Now, the one consistent rule about juries is that you just do not know what they're going to do. When you put 12 random strangers in a room, the outcome is never obvious. But we do know that there are 3 possibilities, broadly. The jury could acquit Donald Trump on any or all of the 34 counts against him. All 12 jurors have to agree on that unanimously. We could get a hung jury if all 12 jurors cannot agree either way. It only takes 1 holdout for that outcome. Or the jury could decide to convict Trump if they unanimously agree he is guilty beyond a reasonable doubt. Again, there are 34 separate felony counts at play here, so this could be mixed and matched in a variety of ways. Understandably, a lot of people are very invested in the outcome of this trial. I do think it matters. But no matter what happens, I really do believe that the process has already been a victory for the rule of law and a rebuttal to the worst, most dangerous aspects of Trumpism. The fact the former president was investigated, charged, and tried by a jury of his peers shows that no one is above the law in America. Of course, that's not Donald Trump's vision of the law. In his view, there is no such thing, crucially, as a neutral, free, and fair process, like a trial or an election. All that matters is outcome. If he wins, it was fair. If he loses, it was rigged. He has said this about everything from his legal trials to multiple presidential elections to the Emmy Awards. That is Donald Trump's authoritarian view of the world. Power trumps all. The powerful get to dictate what happens. It is the opposite of our core civic commitments of equal rights, equal protections, and equal justice under the law. That we are all subject to the same fair processes, and then we respect the outcomes of those processes. It's the basis of the liberal democratic project. In a way, this first criminal trial of Donald Trump has been a big test for America. For the first time in our history, a former president has been prosecuted and tried for committing a crime. We know this process works in some of our peer democratic countries. It's happened in lots of places. In France, in South Korea, Taiwan, where former presidents have been successfully tried and convicted. We've seen the process play out here on the state level. I mean, 4 governors of Illinois have been sentenced to time in prison. Most recently, Rod Blagojevich, who had, by the way, his sentence commuted by none other than Donald Trump. Connecticut Governor John Rowland was convicted twice for corruption, exactly 10 years apart, spending 2 stints in prison. The former state's attorney of Baltimore was just sentenced to a year of home confinement after being convicted of perjury and mortgage fraud. Now, with the first trial of Donald Trump nearing its conclusion, this principle of equal justice for all in America is a pretty bedrock one. And just to be clear, it used to be, I think, a consensus one, and it no longer is. I mean, Trump and his Republican toadies, the people that are going up to New York dressed like Donald Trump to go stand in microphones, they all reject it. And yet this trial is a real success in its own right. For weeks, Donald Trump has had to sit in a courtroom where justice is day in, day out dispensed to regular citizens, faced a judge who was fair and firm while both sides presented their cases to a jury of his peers. All of that happened while another group of Trump lawyers are trying to convince the Supreme Court that he actually has a special status as a former president. He is a special kind of citizen, unbound by the normal processes of mere mortals. Now, Donald Trump does have more access to wealth and power and fancy lawyers than 99.9% of all criminal defendants who step into a courtroom in America. And yet the process played out exactly as it should for any American. He went through the full normal process of a trial, as any person accused of a crime would. That's what's at stake in this New York courtroom, and is what is at stake in the Supreme Court's impending decision about Trump's so-called presidential immunity. Ultimately, our entire liberal democratic order rises and falls on our ability to produce fair and neutral processes that apply equally to everyone and lead to outcomes we can all trust. If it fails, we have Trumpism, authoritarianism. So whatever the jury decides in Trump's case is not actually as important as that process. The trial of Donald Trump, I believe, has proven that that process works, independent of the outcome. And that alone is a rebuke of everything that Trump and his movement stand for. Harry Litman served as Deputy Assistant Attorney General at the Department of Justice. Catherine Christian spent over 30 years as a prosecutor in the Manhattan District Attorney's Office. They both join me now. As someone that worked in that office and someone who's been in the trial every day, do you agree with that assessment, that as a process, as a sort of, test of American equal justice under law, that independent of the outcome, since the jury has it now, this has been a success?
I agree. It has been. Forgetting that it's Donald Trump and a former president of the United States, this trial was orderly. Donald Trump, inside the courtroom, behaved himself relatively. The jurors came on time. There were no hiccups throughout the trial, and most trials are like that. Some, there are hiccups. And you're right, he's not above the law. No one should be above the law. And most defendants, in many ways, he has received special treatment in some of his cases, and just that he has 4 indictments and he's free.
Right.
So that's one thing. But it is good for people to see, whatever the verdict is, whether it's a conviction or acquittal, or if there's no verdict, a hung jury, that's how the system works, and you have to respect that.
It's an important and I'd say beautiful point, really. He was brought to heel all during this trial. He had to do as others do, and it was a full and fair sort of oversight by Judge Merchan. But Merchan is really channeling the law here. It was the law that made him sit, the law that made him show up, the law that subjected him to the same thing that happens to everyone else. People are understandably jittery now. Could there be, say, a hung jury? But unanimity is one of the features of due process that he received, and in a way, that's secondary. It's possible a political response. He could be convicted and sail through. But the fact that the process has happened, it's majestic.
Yeah, this is my point. I mean, again, because we just don't know what the jury's going to do. And I almost feel, if this was the Jan 6 trial where I feel like, I know he's guilty. I saw it. I've read the report. In this case, I think it was a compelling case. And if I as a watcher, I probably think he's guilty. But again, that independence of the process. And one of the things that I've been trying to balance here, and I'd love to hear you both on this as we sort of await this, is that, at one level, it's like you don't want to be like, well, everything that runs the American justice system is great, because it clearly is not. And we know this, and you know it having been in that building for 30 years. So I don't want to say, well, if he's convicted, it's fine. People get wrongfully convicted all the time. At the same time, there's something so insidious to me about the entire Republican Party marshaling behind, as a kind of party line, that this is a corrupt enterprise to its core.
And that was, to me, the most offensive part of the trial, which wasn't about the trial, but the Speaker of the House of Representatives, senators, Congress people, outside of a courthouse while a trial is ongoing, basically trashing the process, criticizing the judge, talk about attacking the independence of the judiciary, criticizing the judge's daughter. That was a statement against the rule of law. I mean, the trial was ongoing and they were doing that. And, you know, that it was shameful to me.
And that's even kicked up a notch in the last few days where you have Republicans lying. I mean, either they're stupid or pretending to be stupid, I never know, but about what exactly the jury's instructions are, saying, well, they don't even have to be unanimous in the same crime, like that has to do with this sort of step-up thing. But you have Marco Rubio and others, I mean, just promulgating these sort of lies and calumny against Merchan and the whole process happening now.
That's exactly right, but that's the political sphere. Somewhere in a courtroom, a kind of homely courtroom in Manhattan, everything that we hold dear happened, and it really demonstrated his being subject to the same processes as ever. I think just that part itself, in fact, kind of brought him down. He's someone who embodies the principle that nobody can tell me what to do, and here, the law told him what to do, and forcefully for several weeks.
Mother Teresa could not beat these charges. These charges are rigged. The whole thing is rigged.
Remind me again, Donald, when Mother Teresa paid off a porn star to cover up an affair? Trump sounds like a man who knows his fate rests in the hands of 12 jurors. And while there's nothing he can do to sway the jury, he and his allies are doing their best to prime the MAGA faithful for the verdict with an alternate universe of lies. In his courthouse comments, he lied about Judge Juan Merchan barring witnesses that his own lawyers decided not to call, and a host of other imagined grievances. He also wrote on his social media, I don't even know what the charges are in this rigged case, literally moments after Judge Juan Merchan's jury instructions detailed the charges against him. Capping off a tear where he all caps screamed about a kangaroo court and claimed that he had no rights because of his gag order, never mind the fact that he could have testified in his own defense but didn't. And if this all seems familiar, it's a recreation of the constellation of election lies in the lead up to the January 6, 2021 insurrection. And Trump's lies are going straight from his mouth into MAGA veins, as evidenced by the signs I saw with my very own little eyes, parroting his claims outside the courthouse today. Joining me now is Tim O'Brien, senior executive editor of Bloomberg Opinion and MSNBC political analyst. Always good to see you, Tim. One of the things that I did notice between the first time I went and this time is that there were actually people there. The first time there were no Trump supporters. There were no protesters. It wasn't a lot, but it seemed very coordinated because he tweeted some specific language. That language was on a sign.
They still haven't learned how to pronounce Justice Merchan's name, however. No. They were out there yelling, going, Merchant.
Yeah.
Merchant Marine.
How much do you think, I mean, having dealt with him and covered him for so long, how fearful do you think he is tonight?
I think everything he's doing, indicates panic. You know, he's got nonsensical, capitalized truths. I guess I hate calling them truths, but, post to his truth account.
Yeah.
And I think he feels cornered. I think he has for some time. Yeah. And as the trial wears along and the evidence creeps up, I think it puts him in a real corner. And I think he feels that, I think perhaps he's been sleeping during some portions of
the
court.
times when he leans back and his eyes are closed.
He closes his eyes,
yeah.
and I actually think he's in this fugue state, and he's trying to pretend that what he's confronting in that courtroom doesn't exist. Yeah. The same way a small child, if you tell a small child they've done something wrong and they stick their fingers in their ears and they say, yeah, that didn't happen. I think that's where he's at.
Fugue state. He tweeted, he did fundraising email saying, I could be in jail tomorrow. Okay. He's sort of freaking out. He's having his allies like J.D. Vance and Elise Stefanik investigate Judge Juan Merchan and all of that sort of stuff. But to me, between the irony of what he did to persecute the Central Park Five, he's now feeling what those 14 and 15-year-old boys were feeling, and he had no empathy for them. But he wants sympathy for feeling the same fear of whether it's going to be guilty or no guilty. And then the other one that I think is so ironic is that if he is convicted, there's a question of whether he could actually lose his right to vote in the state of Florida, where the current governor, Ron DeSantis, he gleefully strips black people of their right to vote and sends his election police after them. Well, my dear, orange is the new black.
That's right. And that's DeSantis looking back to prior efforts to enfranchise people who have been incarcerated and allow them to vote.
Yeah.
And he's now undermined the person he's supporting in this election.
Yeah, it's pretty incredible that he would have to actually petition his former rival, who they went at it and fought. He would actually have to likely petition Governor DeSantis, who doesn't like giving people their right to vote, for him to be able to vote for himself in November.
Well, and I think that is probably the least front of mind thing for Donald Trump.
Oh, I'm sure.
I think what he's really focused on is the idea that he might lose his liberty.
Yeah.
And I didn't think going into this case that was necessarily going to be an outcome.
Sure.
And having sat there, I don't know if you went through this when you were sitting down there, but when you watch the prosecution methodically lay out an airtight case that is really, I think, sitting there irrefutable. Yeah. Whether or not it elevates to a felony, whether or not the jury believes that this, 34 what are currently misdemeanors become felonies because they were in the service of election interference. Yeah. I think that's still a wild card.
Yeah.
But if we get there, I think that Justice Merchan is going to be obviously a pivotal figure in all this.
And the thing is that the way that he did these jury instructions was fascinating in the sense that it gives jurors ways to compromise and convict on some and not on others. There's a possibility of split verdicts, of compromise verdicts, but it's very hard to get around the facts, which the defense really didn't refute.
And it's one of the many elegant and I think graceful aspects of the way that Justice Merchan has presided over this trial. His daughter has been attacked. Yeah. He's been attacked. The entire process in the court system has been attacked. He's an American success story.
Yes, yes.
He's an immigrant who is self-made, and he has sat in that courtroom and been very measured. I think only a couple times he's lost his patience. It's never risen to shouting, but he's gotten very upset a few times at Todd Blanche, who's a court jester, no pun intended. But throughout, I think Merchan has really been an exemplary person that most of us could try to latch onto as an idea about how to conduct oneself in the midst of chaos.
Indeed. It is fascinating that he comes originally from the same place as Judge Aileen Cannon, but they are very different jurists. Very different. Tim O'Brien, my friend.
Thank you, Joy.
Thank you very much.
It took an hour to read those jury instructions the first time. What were you thinking when the jury came back and asked to hear some of them again? What do you glean from that?
Well, first of all, it's not at all unusual. We're in this very sort of nail-biting period once the jury has gone out where questions come in and you think, is there a verdict? And it'll be happening, over the next few days. It's very interesting, the one you raised, though, Steph. They asked, apparently, we'll find out tomorrow at 9:30 if they really want this, but for the entire 55 pages, takes over an hour to read, and that Merchan is not giving them the instructions. He would just have to read it again if they say, we want the entire thing. Why would they want all the instructions, including some really boring, generic ones up front? I'm not sure. So that one actually puzzled me more. The other request, I think, is more meaningful and portentous.
How much can we read into these questions, right? People love to make assumptions based on what outcome they're looking for in this trial. But take your feelings aside. When you heard about what the jury came back with, what did you think?
Well, I thought it was bad for the most part for Donald Trump. When the jury is starting from the beginning, where this is all born from the birth of this alleged conspiracy to promote the election, born at the 2015, I thought that's not a good thing. Why? Because you have David Pecker, who really is number one here, who really corroborates and pulls everything together. David Pecker is far more important, really, than even Michael Cohen. He's so valuable, other than the handwritten notes from Weisselberg. He is center to this case, because if you don't believe Michael Cohen, okay, but I've got David Pecker who's going to poke the holes or fill those holes to make this believable. So if I am the defense, I'm concerned, and maybe speculation, out of the gate, there's some people who are a little unsure, and there's people who say, no, listen, there's corroboration, and we know that you can't just convict on Michael Cohen, but here's that corroboration. It's David Pecker.
Every time I hear his name, I can't even believe at the center of this, it's too unbelievable. A guy named Pecker. Catherine, once, I can't, I'm so immature. Walk us through this process, thank you. When this material is reread, as Harry said it likely will be, then what happens?
So a court reporter will come and read it, not the judge. It'll be a court reporter who will do the readback of the transcript. And after it's done, the judge will look at the jury, and that's it. And if you have any questions, he'll ask the jury. put it in a note. So there's never a jury raising a hand and having a conversation with the judge. And they will go back. And both sides, you look at the jury to see if anyone's like sort of shaking their head like a particular line, which is meaningless. But you're convincing yourself, whether you're the defense or the prosecutor, I was right. That's what they wanted to hear. But that's what you do when you're waiting for the verdict. I was always superstitious as a prosecutor. When I got notes that I thought were good for me, I was cautiously optimistic. So I think this prosecution team are cautiously optimistic because these notes, one would lead you to believe, are really good for the prosecution because, as Jeremy said, they are highlighting, the conspiracy that was hatched at the August 2015 Trump Tower meeting. That's Josh Steinglass. He was the lead prosecutor. That's where he told them to focus. At that meeting, that's when the conspiracy to promote the election by unlawful means was hatched. And that's the testimony they asked for back, Mr. Pecker. And they also asked for Michael Cohen's testimony to see if it matched David Pecker's testimony. So that is good for the prosecution, we think.
So they're all on pins and needles, and Donald Trump himself doesn't get to sit in Trump Tower, doesn't get to go golfing, can't be typing away on his phone. He has to sit there, show up for these deliberations while the jury is in a sealed room. This has to be torture for him.
Yeah, and I think we're seeing him act out on social media, and we're seeing, look, Trump has historically thought that these indictments were good for him. He has played this as a political trial versus a real legal trial. He has made it candidate Trump and not defendant Trump. And this has really backfired for him, at least with the civil cases. We'll see for this. But, he definitely thinks that he can use this to an advantage. But in the end, he is just a criminal defendant like anyone else.
Reading tea leaves could also backfire on all of us. But I know you have noted, Harry, that there is one juror that some people think could be problematic for the prosecution. Why is that?
Well, as part of this process of going over everything, being maybe obsessive, prosecutors are. You remember, both sides took risks at the end of the jury selection process. They had to go with people that they would have if they had more peremptories tried to eliminate, but they didn't. So they start with one or two that they're worried about already. And yes, there is a couple people, but I have noticed one whose body language seems to suggest maybe a little bit arm's length from the others, whose attention seems a little less clear-eyed and vivid. But look, that's a standard feature for any jury trial, and especially at this point, you focus, is there the holdout? And can I just say one more quick thing?
But it only takes one.
It only takes one. And of course, and look, in a way, that's part of the system. I mean, he had to subject himself to the system. If he gets wins because of a holdout juror, it's a disaster politically. But the rule of law has had its way. Unanimity is part of it. He got everything and nothing more. That was good in and of itself. I just want to say the evidence, besides being about Cohen, focuses specifically on Trump. Trump is in the meeting. Right. And then there's the phone call that Pecker remembers.
I'm not from Harry.
Because he's there giving a presentation, the President of the United States on the phone. And during this phone call, the President of the United States says, deal with Cohen. He's my guy. So it totally corroborates in the mouth of Trump the role that Michael Cohen, and the DA says Michael Cohen played.
Jeremy, if you're Donald Trump's attorneys right now, sitting there with him minute after minute, hour by hour, what are you telling him?
I'm leaving, but I can't tell him. What am I telling him? I'm telling him that, there's two separate things.
Can you please pay me today, sir?
If I'm having that conversation, it's too late.
Yes.
No, what am I telling him? I'm telling him that this is a concern, this what was asked and what the readback's going to be. Hold on to it. I can't promise you what's going to happen here. We'll find out. Control yourself inside that courtroom. Though I don't think they're really controlling anything. I think Donald Trump is calling the shots. And that's the worst thing that's possible. At some point, I used this term before, you have to have some chutzpah. In this case, it's not Donald Trump. It's actually actually his attorney is standing up and saying, I'm the boss here. This is my house. This is my courtroom. This is my trench. You do what I tell you to do. Donald Trump doesn't operate that way.
God
that's
bless
why
you.
we
You know
are
that's
what we
not
are.
happening.
Of course not. You didn't ask me that question.
That's true. Catherine, I know I'm asking you to make an educated guess between the three outcomes. Not guilty, guilty, hung jury. What do you think, based on what you've seen, is the most likely outcome? And is a hung jury a clear victory for Donald Trump?
Yeah, for a defense attorney, the next best thing to an acquittal is a hung jury because, yes, it will be possibly retried, but maybe it won't be. You hate to retry a case as a prosecutor because you got to bring the witnesses back, and this was a big deal.
And they know your playbook.
And they know the playbook. So that would be a very big victory. I do not think, they say it's easy to say it's not going to be not guilty. I don't think 12 jurors are going to say not guilty. I'll be shocked if that happens, but I don't think that's going to happen. I wouldn't be, I think all of the evidence leads to 12 jurors saying guilty on all counts, but I would not be shocked if there are jurors that we don't know who just say, I just can't go there, or I can only go there for the checks that he signed. The 9 checks. But those ledger entries, those invoices, maybe not. And then you would have guilty on 9 counts or 11 counts because there are 11 checks, and then hung jury on others or not guilty on others. That also happens in cases where you have multiple counts. And I always said as a prosecutor, that's good. That means it's appeal proof because it shows that the jury was thinking and they were thoughtful. They said guilty on this, but not guilty on that. I think D.A. Bragg wants 34 counts guilty. I don't think he'll think it as a victory. But I think, it could end up that way. But if I was betting, I would say guilty.